Namaskar. Warm welcome to all our participants and a speaker for the day, Vikram, sir. Without wasting any further time on pleasantries, I request CA Rani to formally welcome and introduce the speaker and get the session rolling. Over to you, madam.
Uh, Good evening, everyone, and wishing you all a very happy and productive new year. Today, we have a very special session. In fact, best way to start the events of KSCAA for the year. The topic is understanding the legal principles and jargons when we present a tax appeal to the statutory authorities. So understanding of legal principles and jargons are very, very critical, especially when we present our case to statutory authorities. In fact, the outcome of the case very much depend on how well you present the case. So this session is very much relevant. So let me introduce and please join me to welcome our distinguished speaker, Mr. Uh, Vikram A. Huligol, who is Senior Advocate, High Court of Karnataka. And let me introduce our speaker today. Mr. Vikram A. Huligol has completed his BSc LLB from ILS Law School, Pune, and LLM from Harvard Law School. And he's practicing as advocate since January 2005. He has served as Government Advocate, Government of Karnataka, and also Senior Standing Counsel with Central Board of Indirect Taxes and Customs, Government of India, and now designated as Senior Advocate by the High Court of Karnataka in December 2021. Thank you very much, sir, for accepting our request to address us. And we are really looking forward to listen to you. We welcome you for the session and looking forward for your session. Thank you, sir.
Thank you, Mr. Deepak. Thank you, Ms. Rani, for the extremely kind welcome and introduction. First of all, just a couple of things. One, my sincere apologies for having to advance this session. Originally it was scheduled for Saturday evening, but due to some unavoidable circumstances, I couldn't participate on Saturday evening. I have to go somewhere else. So my sincere apologies for doing this last minute and having to reschedule. And thank you, of course, for being kind enough to allow me to reschedule. So today's topic really, as Ms. Rani rightly said, it is an important topic, and simply because eventually when we are as practitioners appearing before appellate forums, tribunal, sometimes the High Court, Supreme Court also, there are various legal principles involved which underlie the proceedings. Now, everyone knows the substantive law, or at least we're supposed to know the substantive law. For example, if you're doing an income tax case, we're supposed to know whatever provisions are involved, whether certain deductions are allowable or not. Similarly, if we're doing a GST case, we're supposed to know what the relevant provision is, whether input tax rate is allowable or not. That is something which we call the substantive law, which we are supposed to know, because that is the real case itself. But there are several underlying legal principles and, fortunately or unfortunately, complicated jargon involved, which are often overlooked but are extremely important as practitioners to know, because that really, a lot of times, my experience tells me that a lot of times it's the first principles of law, it's the first principles of legal, the law itself, legal principles that determine the outcome of the case. And very often we miss the woods for the trees because we focus too much on the actual issue itself, the actual dispute, while overlooking all of these smaller aspects which are very important really, and which very often are determinative of the final outcome of the case. So my endeavor today, I was telling Mr. Deepak just before the session began, that as as a legal practitioner with about 2 decades of experience now, we are exposed to some of these practical aspects of the law, if I can call them, which sometimes are overlooked. There are most of us are very well read, are very immersed in the subject, and we know the law, and we know the provisions of the Income Tax Act, the provisions of the GST Act, and so on. But my endeavor today is to bring to the table my experience over the last 2 decades as far as how to maneuver around these legal principles, how to effectively use those legal principles to ensure that our clients are benefited to the maximum when we are representing them in an appellate forum or in the tribunal, as the case may be. So that's what my endeavor is over the next 1.5 hours. And how I've structured this, I don't want to make this too dry a session. So I've not brought in too many legal jargons, but I want to dedicate most of my time to the law of precedents, which is very, very, very important. There are first principles of law of precedents, which most of us, even as legal practitioners, when we are asked, just the other day, I'll give you an example. I was before the single judge of the High Court, or not even my case going on, and somebody else's case was going on, and the issue was quite fairly straightforward, where the petitioner in that case had approached. I'm not able to recollect whether it was an income tax matter or GST matter, but the appellate forum belatedly. Now there is a limitation period within which the assessee is supposed to approach the appellate forum. He doesn't do so. There is a condonable period within which the appellate authority has the power to condone the delay. He misses that bus as well. What he then does is files a writ petition, says, please condone the delay in me approaching, or please direct the appellate authority to condone the delay approaching the appellate forum and hear me on the merits of the case. So this was not my case. I frankly was probably reading my file or doing something else. And then the judge asked me, he called me and said, Vikram, I need your help in this. I said, okay, how can I help the court? The court said, there is a judgment. This was maybe in the month of March 2021. I still remember the case. Fortunately for me, it was a case I had appeared in my capacity as a government advocate then, where I had opposed the petitioner's prayer in an identical fact circumstance. That was in respect of an appeal before the appellate authority for advanced rulings. Excuse me, one second. There again, the assessee had approached the appellate authority for advanced rulings belatedly, and then because the appellate authority said, I don't have the power to condone the delay, he filed a writ petition. This is in the case of NMDC, National Mineral Development Corporation. So I had opposed that prayer, and the division bench of the High Court had said, even exercising writ jurisdiction under Article 226 of the Constitution, which is a very, very wide discretionary constitutional power conferred on the High Court said we cannot condone the delay. And if I'm not mistaken, the matter was either left, it was not taken up to the Supreme Court, or the matter was dismissed outright in the Supreme Court. But that was the law in March 2021. In maybe August or September 2021, another division bench, another case, almost identical fact circumstances. I think this was a service tax appeal in the case of, I think, Simplex, where the High Court said, yes, we will direct the appellate authority to hear you on merits. Unfortunately, that previous judgment of NMDC was not brought to the knowledge of the High Court subsequently. Now, why I'm telling this long drawn story is this: why, even after having practiced for nearly 2 decades and after having been conferred with the honor of being designated as senior advocate, the court, when it asked me this simple question, Vikram, what do I do? There are 2 judgments. One, NMDC, Division Bench of Karnataka High Court. 2, Simplex, Division Bench of Karnataka High Court. Exactly polar opposite views. What am I supposed to do? And why I'm telling you this is, at that point when the court asked me this question, I frankly was stumped for an answer immediately. Yes, the answer I can tell you in short is, generally speaking, 2 coordinate bench judgments, the subsequent judgment should be followed. But there are, I'll go into it more in detail, but I will give you enough and more riders and caveats to it. But why I'm telling you this is these are first principles. You're supposed to know it. It could happen tomorrow when you're practicing before the ITAT. There'll be two coordinate bench judgments of maybe two judgments of coordinate benches of the ITAT. And the court will ask you, what am I supposed to do? And here one court says deduction allowable, second bench says deduction not allowable. What am I supposed to do? So, those are the principles which I'd like to touch upon over the course of the next hour or so, hour and a half, so that some of the doubts, I certainly can't claim that over the next 1.5 hours, I'll be able to clear all your doubts, because very frankly, I myself have several doubts, including on the question which I just posed, which the court posed to me in that other case. So we'll just discuss some of these principles. So first topic is the law of precedence. We'll spend most of our time on that. Before anything else, before going into the nitty-gritty, the finer details of the issue, what is the law of precedence? Very frankly, we all have studied the statutory law. There's an Income Tax Act. There is a GST law, there was a VAT Act, there were several an entry tax laws, so on. That is the law that is made by the legislature. And no legislature in the world can possibly claim that the law takes care of every contingency, every possible fact scenario that may arise in the future. There are, of course, very well-drafted laws, and there are, of course, some extremely poorly drafted laws which will give rise to more disputes. But at the same time, even that well-drafted law, the law can't possibly be so well-drafted that there will be no interpretational issues that arise from it. So that is where the judiciary steps in. And when I say judiciary, I include the tribunals within, although strictly speaking, traditionally the judiciary will be the hierarchy of courts under the civil and criminal procedure codes. But when since I'm speaking to an audience of chartered accountants, I'm certainly including even the tribunals. So whether it's the sales tax tribunal or the income tax tribunal or the various tribunals that are set up, the National Company Law Tribunal. So the judiciary has to step in and interpret those laws so as to clarify what the legislature possibly intended by enacting that particular provision, or when they are interpreting that provision, what facts situation the legislature sought to address. So that's where the courts have to step in. Now, just like laws are binding on us, nobody can possibly claim that once a law is validly enacted and is gazetted, notified to be brought into force, nobody can reasonably argue that that law is not binding on us. In fact, we all know that ignorance of law is no excuse at all. Once the law is there, you're supposed to know the law, you're supposed to follow the law. That is legislature-made law. Similarly, judiciary-made law is also equally applicable, since it is nothing but an interpretation of an already existing set of laws and rules. So therefore, that is what, broadly speaking, is the law of precedence. Therefore, just like we have legislature-made law, we have judiciary-made law, and both are binding. Of course, this is oversimplifying the situation, because then we go into what is binding, what part of the judgment is binding, what part of the judgment is not binding, on who is it binding, and so on. That is what I will discuss over the next maybe half an hour or so, which I will dedicate to this. So, general rule is that a bench that is higher, that is a forum that is higher than the next forum, any judgment by a higher forum will be binding on the lower forum. That is, it's not rocket science. Supreme Court judgments are binding on high courts, high court judgments are binding on tribunals, and similarly, tribunal judgments are binding on appellate authorities, and so on. So the lower down you go, you are bound by the decision that is being rendered by a higher forum. So that is, again, very, very broadly speaking. Why exactly do we need this law of precedent? One, I said, of course, is that just like it's legislature-made law, judiciary-made law, but why do we follow this hierarchical structure of the law of precedence? One of the reasons is just like a legislature made law, we all expect a certain amount of certainty. And that is the most important aspect of law of precedents. If courts that were uh, lower down in the hierarchical structure were allowed to ignore judgments of higher fora, and mind you, there are several judgments of even the Supreme Court which we can reasonably argue are wrong, but there is absolutely no authority for the High Court or the tribunal to say, listen, the Supreme Court did not consider this provision. If this provision had been considered, the Supreme Court would have come to another decision. The lower fora don't have that option at all. They are bound because there is a need for certainty. Otherwise, what will generally happen is one tribunal will say, no, this is my interpretation of the law. Supreme Court judgment hasn't considered this. This is my interpretation. Another bench may have, just like any reasonable human being can have two different views on any given subject. The other bench may say, listen, the other bench also may not have correctly interpreted the law. I have my own interpretation of it. I'm not going to follow the Supreme Court judgment. I'm not going to follow the High Court judgment. I'll do whatever I want. This creates a situation of utter lawlessness and chaos. Now, that is exactly what the law of precedents seeks to avoid from happening. We don't want a lawless state where each tribunal member, each High Court judge is permitted to do what he or she likes. So therefore, there is a strict rule of precedent that whatever decision that is being taken by a higher court, right or wrong, you may have your own views on it. We all have our views on various judgments in the Supreme Court, and we have quite often criticized judgments of the Supreme Court as practitioners. But if we are sitting as judges, if we are sitting as tribunal members, or even as legal practitioners, we cannot possibly take the view in a legal proceeding that Supreme Court judgment should be ignored or should be distinguished. You can distinguish on facts, of course, that's a totally different situation. But you cannot say, no, the Supreme Court judgment did not follow this particular provision, did not follow this particular earlier judgment. It takes a contrary view, therefore I will take whatever view I want. We cannot do that. We are strictly bound by the law of precedents because it promotes certainty. It ensures that there is the rule of law. Just like we may disagree with various statutory provisions. We disagree with several provisions of the Income Tax Act. We disagree with several provisions of the GST law. GST law particularly. There are several provisions, several notifications, several circulars which are quite often, if I may use the word, obnoxious. But we have no option but to follow it. Of course, there we can challenge it in an appropriate court of law. But similarly, we may disagree. We may find a Supreme Court judgment or a High Court judgment or an income tax tribunal judgment to be obnoxious. But if we are appearing before a lower forum, we have a duty to follow it. The judicial member has, or the technical member has a duty to follow it. There is no other option. Otherwise, the rule of law will be diluted. And that's what, at all costs, we should avoid such a situation. And it promotes stability after all, because there has to be some continuity to law. We can't have a new law every day. We can't have a new interpretation every day. So if the Supreme Court has interpreted a particular provision or the High Court has interpreted a particular provision, we'd like that to continue for some time at least, because there is some stability. It may be right or wrong, but at least it promotes stability. There is some consistency of rulings, and most importantly, it promotes judicial discipline. All right, so that is what the law of precedents seeks to promote, seeks to ensure. Law of precedents, is it a written law? Frankly, other than a law which says, other than an article of the Constitution which says the law laid down by the Supreme Court is binding, there is no other statutory law which needs to say that the law is binding. There is Article 141 of the Constitution, which says that the law declared by the Supreme Court shall be binding on all courts within the territory of India. So that is written in black and white, no issue there. But the other side of the law of precedents, where the law laid down by the high courts, law laid down by the tribunals, what I said is binding on the lower fora, it's not written in black and white. But the law of precedents is a part of the rule of law of our country since we adopted the common law system that the British had introduced. So there is no argument over there, even though it may not be a written law. Now, what orders are binding? Or is it a final order that is binding? Or are even interim orders binding? Now, that's a very interesting question again, which we will quite often be faced when, as legal practitioners, we appear, or as chartered accountants, we appear before various judicial forums. Is a final order binding? Yes. Answer simply is yes. But the question is, what part of the final order is binding? I'll come to that in a while, because when we discuss obiter dicta and ratio decidendi, I'll discuss that. But final orders, yes, are binding. Are interim orders binding? Frankly, law of precedents does not make interim orders binding. So if there is an interim order where quite often when we go to the high courts, or sometimes even in the lower court, before the tribunals, a stay order is passed giving reasons. It says, let's say we approach the high court on a particular point of law. The high court will say, learned so-and-so advocate for the petitioner submitted this. Learned advocate for the respondent state or Union of India submitted this. On careful perusal of the law, the court is of the prima facie view that the stay order is to be given for whatever reason. They will give reasons. Now, they may analyze legal provisions while giving that interim order. But can you use that as a precedent before the income tax tribunal? The answer is no. That is not binding, because that is not a final order. It is a prima facie. It is just a preliminary observation of the court for the limited purpose of giving an interim order. So please don't take an interim order and say, please, this is the interim order passed by the High Court. This is the law laid down. There is no law laid down by the interim order. But there may be interim orders passed staying the operation of a particular provision. Very rare, very rare. There is a presumption of constitutionality of all provisions. Very, very rarely do high courts or even the Supreme Court stay the operation of the act or a provision of law itself. But quite often, the operation of a notification will be stayed. Quite often, the operation of a particular circular will be stayed. Now, let us say the department seeks to rely on that particular notification or a circular in a matter before the income tax tribunal where the High Court has stayed that notification. In such a situation, yes, you would be right in pointing out to the court that that notification has wrongly been applied by the department because it has been stayed by the High Court or it has been stayed by the Supreme Court. Therefore, please don't apply the notification to the facts of the case. Quite often, the tribunal will say, okay, we will also stay, let us await the outcome. But I'm saying this for the limited purpose of pointing out to the audience that you would be right in showing a stay order where a particular provision, notification or circular is stayed, and where the department seeks to rely upon the same provision or notification. You would be right in doing so. But please, I would like to state once again that if there is any preliminary just an observation saying that the demand raised on so-and-so assessee is stayed for ABCD reasons. Now, those ABCD reasons will not be binding on the tribunal. But if there is a particular stay order of an order staying a notification or a provision, now that can certainly be used before the tribunal to say that the notification has been stayed. The notification itself has no force in law until that stay order is in force. So therefore, kindly stay these proceedings as well. So you can do that. Now, to that extent, yes, an interim order would be binding. Now, I'm again caveating this with the fact that there may be 101 other situations which I may not be able to cover, which I will not be able to cover. But this is again a bird's eye view of how interim orders are to be treated. Interim orders are not to be treated as precedents except for the limited purpose I just mentioned. Quite often, what also happens is there are orders passed by the higher forum, be it the High Court or the Supreme Court, or it can't be Supreme Court, let's say High Court, on a particular point of law. Now, the same point of law is involved in an appeal in which you are appearing before the income tax tribunal or or any other tribunal, or before a lower forum. Very often we have seen that the department will rather unfairly say that, please tell the tribunal, please don't apply this judgment because the department is in the process of filing a special leave petition. Therefore, please keep your hands off. I can tell you categorically that such a submission is not only unfair, but also incorrect for two reasons. One, intention to file an appeal is absolutely no reason for the tribunal to ignore a binding precedent. So when there is a binding precedent of the High Court or of the, like I said, situation may not arise in the Supreme Court because there is no higher appellate forum. But I'm sure most of you have come across a scenario where the department will come forward and say, yes, High Court judgment is there. Department is preferring an SLP or has preferred an SLP. Therefore, please keep this matter in abeyance. That is wrong. You have every right to request the tribunal to dispose of the matter in light of the law laid down by the High Court, which of course you will only do that if it is in your favor. So please keep that in mind when you appear before the income tax tribunal. The second reason is there is one order 41 rule 1. I won't go too far into CPC because then it becomes too much of a legal practitioner discussion. But there is one provision in the Civil Procedure Code which specifically states that the execution of a judgment, that is, of course, in that context, it is a civil court order, execution of a decree, need not be stayed merely because of pendency of an appeal. Because the appellate forum has the power to grant a stay. So therefore, I am taking this argument one step further. Department officials quite often will unreasonably say, no, department is going in SLP, therefore I will not apply the High Court judgment. Totally wrong. Even assuming SLP is filed, let us say SLP is filed, pending, even then they have no right to tell the tribunal, ignore this High Court judgment because the High Court judgment is binding on them. Third fact situation, let us say the Supreme Court says issue notice. Even then, I would stick my neck out and say, even then it would be wrong for the department to come forward and say that the High Court judgment should not be followed because there's an SLP that is pending. But in light of Order 41, Rule 5, unless there is a stay of that judgment, quite often department, when the revenue approaches the Supreme Court, they will ask for stay. Quite often the Supreme Court will not give stay ex parte without hearing the other side. They will simply say notice, let's see what the other side has to say. Until then, I will state that the judgment of the High Court is binding. The tribunal is bound to follow it. And worst case scenario, if the stay is rejected, if they say, okay, issue notice, we will hear the appeal, but your stay application rejected, then certainly the tribunal has no option but to follow the High Court judgment. So that is how you would have to approach a case when there is a judgment of the High Court, when the department is intending or has already filed an appeal before the Supreme Court. So please keep this in mind. Before moving into certain smaller aspects of the law of precedents, I said that a final order of the higher forum is binding on the lower forum. What part of the law is binding? Now that is where we come to the concept of ratio decidendi. As we're speaking of legal jargons, we lawyers love to complicate things, and of course we can't blame for these concepts. Can't blame Indian lawyers because this is all these are British concepts which we have just borrowed. But there is something called a ratio decidendi and something called an obiter dicta. First principle, obiter dicta is not binding. Only the ratio decidendi is binding. So the next question is, what is ratio decidendi? What is obiter dicta? Ratio decidendi frankly, is the law that has been laid down in the specific fact situation of the case that has been decided by the higher forum. So therefore, if the High Court is called upon to decide a particular question of law, and in answering the question of law has laid down certain legal principles, those legal principles form the ratio decidendi of the particular judgment. And it is that ratio decidendi and the ratio decidendi alone that is binding on the lower forum. So therefore, be very careful. Very, very often, we all make mistakes where we go to a tribunal and say, my lord, this is a covered matter. Please be very careful while doing that, because when we say covered, we say that we mean to say that particular case is covered by the ratio that is laid down by the higher forum. Now, before we make that submission, we need to be responsible enough to ascertain what is the ratio that is being laid down by that particular judgment. And only then should we venture to tell the tribunal that the matter stands covered. So therefore, kindly take the trouble or the time to go through the judgment. Make sure that is precisely what the ratio of the judgment is. Because let's be very clear, law of precedence will apply only in a given fact situation. So if the facts are identical to a decision that has already been rendered, only then is that judgment binding. So make sure you read the facts of that judgment. Make sure you read the judgment itself and find out, ascertain what the ratio of that particular judgment is. And only then can we responsibly tell the tribunal that the matter stands covered. Otherwise, far too often, and I myself, as a department counsel, I have come across several judgments where several cases where tribunals have blindly, and I'm using this word carefully, blindly followed judgments of the Supreme Court without any application of mind. I remember there was a SISTAT judgment that was appealed, and as a department counsel, I had it was held in favor of the department by the SISTAT. Matter came to the High Court. I think it was Central Excise Appeal or a CST. I think it was Central Excise Appeal. The judgment was just about 3 pages. Learned Counsel for SSC submits this. Learned Counsel for Revenue submits that the matter stands covered squarely by a judgment of the Honorable Supreme Court in so-and-so case. The submission of the Learned Counsel for Revenue is accepted. The matter is disposed of in terms of the judgment in the Supreme Court. In terms of the judgment in that particular Supreme Court case. When the matter came up for final hearing before the High Court, and I pulled out that Supreme Court judgment, I was rather shocked, and this is not a comment on any particular tribunal or the DR or anyone. That judgment was in an entirely different fact situation. That judgment laid down a completely different law. And how the tribunal possibly thought that it's covered by the judgment is simply for the fact that it is the easy way out. Now, why I'm saying this is not to criticize tribunal members, but to critically analyze our own performance as practitioners before these tribunals. I'm not saying that private counsel are not guilty of such incidents. Such incidents are, of course, it may be 60-40 in favor of the department, or the department will rely on a judgment which has no application. But experience in the High Court that even assessee counsels have done that, because we are also, let's be practical, we are guided very, very often by what the client tells us. The client will say, sir, one Supreme Court judgment is ನೋಡಿ sir, ಅದನ್ನ dispose ಮಾಡಿಸಬಹುದು. We'll immediately move the matter. We'll say covered matter. The tribunal member, for him, it's he trusts the department counsel or the SSC counsel sufficiently to say yes, it must be covered. Why would he bother saying no, give me that judgment, let me examine it? Very often he'll say, I thought covered, okay, covered. And very often mistakes are made. So my humble plea to all of you is, please analyze these judgments and pull out what the ratio is. And as I was saying, the ratio is the actual law that has been laid down by the judgment which is being relied upon. Then we come to the concept of obiter dicta. Obiter dicta is exactly what the ratio decidendi is not. Very often, more so, the tribunals thankfully don't write very, very verbose judgments. Most of their judgments, with some exceptions, of course, are more to the point. These are the questions of law. This is the Supreme Court judgment that's relied upon by the SSC's council. This is the judgment relied upon by the Department Council. I am of the opinion that the law is laid down in this judgment, and that's generally what they do. It is a good habit. Unfortunately, when we go to a higher forum, the tendency quite often is to make certain observations in that judgment which really did not fall for the consideration of that particular court at all. Now, for example, let us say there is a particular issue regarding whether certain input tax credit should have been availed or not. And this is, let us say, for the first year of GST 2017-18. The council says, see, I made a bona fide mistake and my GSTR 3B, I made a mistake. Therefore, kindly allow me to correct it now, because now, of course, they'll say section 39(9), that time period is over, so on. So kindly allow me to correct it. The correct approach, in my opinion, for the High Court then to do would be to see if there are any judgments of the Supreme Court. Recently, I'm sure most of you would have come across this in Bharti Airtel judgment. The correct approach then would be go to Bharti Airtel, see if that fact situation applies to this. If it is not, say that, then say Bharti Airtel was in a different fact situation. Therefore, in the facts and circumstances of the case, I deem it appropriate to direct the GST department to open the portal or whatever the judgment. We've seen a number of such judgments recently. But very often what the courts will then do is, we have come across, in passing the judgment, they will say, we have come across several such cases where not only in GSTR 3B, but also in GSTR 1 and also in GSTR TRAN, that assessees for the initial few years of GST 2017-18 and 18-19 have come across such situations. Therefore, the department must ensure that all such cases, the assessees are not put to any inconvenience. Now, that is dangerous. That is where you enter the realm of obiter dicta. And like I said, most of these situations arise at the High Court, and if I may say so, more so at the Supreme Court level, because sometimes, as some of you may have followed these recent judgments of demonetization and say some freedom of speech judgment, you'll not only have a majority opinion, you may have a concurring opinion, as has happened in the freedom of speech case, where Justice Nagaratna concurred with the majority. Then you may have observations which may not have been required in the fact situation of that particular case. But then when you are faced, when you approach a lower forum, the tendency would be to follow it. But be very careful. A lot of these observations are obiter dicta, and yes, it would be well within your right to even tell a lower forum that, see, this High Court judgment is, yes, it is there. We are not saying it is wrong, but what is binding on you is only the ratio decidendi and nothing more. So kindly don't follow these other observations because they are in the nature of obiter. Practically difficult, I completely admit. Sitting as a tribunal member, my tendency would be to follow whatever the High Court says. Sitting as a High Court judge, the tendency would be to follow what the Supreme Court says. But all I'm saying is, it would be well within your right to, let us say there is some obiter which is in favor of the department, obiter dicta of the High Court. You can say, yes, the obiter dicta of the High Court should not be followed because that is not the ratio of the case. But once again, I'm going to complicate things further. There are judgments which, if I'm sure the reading material has been circulated. I don't want to go through each of these judgments. It will take too much time. But there are judgments which say the obiter dicta of the Supreme Court is also binding. Then, well, then you have no option but to follow even the obiter dicta. I'll complicate the matter further. There may be some obiter dicta which is contrary to, let us say, the obiter dicta of a judgment of the Supreme Court judgment of 5 judges. There is a ratio of another judgment of only 2 judges. Then what do you follow? Again, there are judgments which say if it is ratio, you follow the even if it is of a lower strength, you follow the lower strength. So it gets very murky. That is where you would have to do your research, make sure you pull out the correct judgments. Very frankly, you can pull out judgments both ways. I can assure you that in my experience in the Advocate General's office as well, there are cases we have relied upon to say that obiter dicta should be followed. There are judgments we have pulled out to say that obiter dicta should not be followed also. So it's murky to say the very least. But broadly speaking, I don't want to confuse everyone more than I already have. But broadly speaking, suffice to know that it is the ratio and the ratio alone that is binding and not the obiter dicta. And it is those rare cases. If we want to get into a very intricate legal debate, we can certainly go into whether obiter of a higher strength is binding or the ratio of a lower strength, all of that. But I can assure you that those situations are rare. It is there, but it's not something we come across very, very often in our practice, particularly before the tribunals. So my only suggestion is my reading material will throw some light on it in case the unfortunate situation does arise where that you may need to distinguish the obiter of say the High Court or even the Supreme Court sometimes. So, but just keep that in mind. But the broad principles, I think, if you keep in mind, it should be more than sufficient for the time being. Now, there are some fact situations which I thought I'll take you through because since the focus of this particular webinar was to be was vis-a-vis appeals before the income tax tribunal. So this thought I'll take a bit of a deviation maybe for the next 10 minutes and then I'll close on precedent since we're taking a fair amount of time on precedent itself. As to what is the power of the ITAT, I mean, as I said, it is a judicial forum. There is no doubt about it. It falls within the scope of what is Article 227. So therefore, the Income Tax Tribunal is within the judicial superintendence of the jurisdictional High Court. The tribunal was constituted because all tax disputes, including income tax disputes, were kept outside the scope of the civil courts. Otherwise, if we have a civil dispute, we have to go to a civil court. But since there are, in view of tribunalization, all those income tax disputes will go only before the income tax tribunal. So you will go for the CIT appeals, I guess, an assessment order, you go to the income tax tribunal, and then High Court, and so on. So therefore, it has all the powers of a court of appeal under the CPC, so that there is no dispute about. So therefore, the jurisdiction of the tribunal is fairly well settled. Now we come to the slightly more complicated nitty-gritties. What would bind a particular tribunal bench? Would a full bench of that particular tribunal, let's say the Bangalore bench, a judgment of a full bench, and I say full bench, 3 judges, would it bind a 2-judge bench? Answer simply is yes. So therefore, a bench of a particular tribunal must follow the decision of a higher quorum. Should a bench comprising of 2 judges follow a judgment, a previous judgment of the same strength, that is a previous judgment of 2 judges of the tribunal, again, judicial propriety and comity requires that the subsequent bench also follow the judgment, even if it is of co-equal strength. Otherwise, once again, like I was saying, it gives rise to uncertainty, gives rise to a sort of chaotic situation where two judges of the tribunal will write whatever they want on any particular given provision of law. And that's the last thing we want. First of all, there is enough uncertainty in income tax and GST law. The last thing we want is further uncertainty. So therefore, a 2-judge bench judgment would be binding on a subsequent 2-judge bench. But there is a way out. So if a 2-judge bench of the tribunal differs from a previous judgment of a co-equal strength, the only remedy then would be to refer the matter to a larger bench. Therefore, it would have to be referred to a three-judge bench for a particular reason, saying that, see, there is a judgment, yes, it is binding on me, but I differ from that previous judgment for A, B, C, D reasons. Therefore, I place it before the president of the tribunal to constitute a full bench in order to resolve this particular dispute. That is the correct way of doing it. And that is, in fact, if I gave you that example before I started speaking, that is what the High Court also is required to do. There was a single judge faced with two High Court judgments. A subsequent judgment which said you can condone the delay, previous judgment which said you cannot condone the delay. The single judge, the correct way would be for him to place the matter before the division bench and say, listen, I am faced with two judgments of the High Court. As a single judge, I don't know which one to follow. Although generally speaking, the later one should be followed, but the later one, unfortunately, in this case, did not refer to the previous judgment. So in Simplex's case, there was no reference to NMDC's case. So therefore, what I told the single judge was, you place it before the Chief Justice to constitute a three-judge bench. Let them resolve this issue once and for all. Then, of course, the Supreme Court is always there. If whoever is agreed, the department is agreed or the assessee is agreed, they have the option of going to the Supreme Court. Otherwise, a three-judge bench will decide it. Similarly, in the income tax tribunal as well, the appropriate procedure, if a two-judge bench is faced with a judgment on the identical question of law, and please remember, only an identical question of law. If there is any change in the fact situation, if there is any change in the provision, let us say there's been an amendment to that particular provision, then that previous judgment would not be binding. If the same fact situation is applicable to the same provisions of law, then the second bench must follow the previous bench order. If it wants to distinguish it, it can do so, but it has to say why the fact situation is different. But if it cannot distinguish it, it has to place them, and if it disagrees with it, it has to be placed before a full bench for a final verdict on the full bench, so that there is, again, like I said, it promotes certainty. There is also a situation where, let us say, there is a High Court judgment of the jurisdictional High Court. Let us say Bangalore bench, Karnataka High Court judgment, but there is a full bench which is contrary to the High Court judgment. Then what happens? Very simple, follow the higher court. The full bench judgment, if it is contrary to a High Court judgment, once again, I repeat, in the same fact situation, with the same provisions of law, you must follow the High Court judgment. Otherwise, it would be judicial impropriety, because the High Court judgments of that jurisdictional High Court are certainly binding. Now, a slight complication. What if it is not the jurisdictional High Court? Let us say a Bombay High Court has given a different judgment. There you would have to tread very, very cautiously. The Bombay High Court judgment would certainly have strong, and I say strong, very, very strong, persuasive value. But their judicial propriety would require the income tax tribunal bench of 2 members to follow the full bench judgment, because strictly speaking, the Bombay High Court judgment, as per the law of precedents, is not binding on the 2-judge bench. You can certainly follow it to an extent of saying, yes, there is sufficient doubt. But if you have a full bench judgment of the very same bench, the law of precedents requires the tribunal to follow it, irrespective of what another jurisdictional High Court has said. Supreme Court, of course, it's a no-brainer. Supreme Court, it must be followed. Doesn't matter what any other High Court, what a full bench has said. If the Supreme Court has taken a particular view under Article 141, it is binding, and you have no option but to follow it. Then you have a further complication of what happens if there is, as I was saying, there is a later judgment there is a judgment of the High Court which covers the matter. There is a later judgment of the High Court which also covers the matter, or which probably takes a slightly divergent point of view. As practitioners appearing before the tribunal, I would suggest that you refer only to the later judgment. I was giving that example of NMDC vis-a-vis Simplex because it's a classic case where there are two coordinate bench judgments on the same point of law. But if you were applying the High Court judgment to the tribunal, since Simplex came out after NMDC, my suggestion would be that to submit the judgment of the in Simplex's case, simply because it is a subsequent judgment, and it is presumed that the High Court has passed that order after considering the previous judgment. Unfortunately, in the fact situation I am giving you, that had not happened. Now, as I was saying again, conflict between two benches of equal strength, follow the later judgment. If there is a larger bench of the High Court, let us say a 3-judge bench of the High Court, which lays down a particular law, but for whatever reason, a 2-judge bench judgment of the High Court lays down a contrary position of law, then what is the tribunal supposed to follow? In such a situation, even though the later judgment lays down a contrary position of law of precedence requires that the full bench judgment be followed. And I know this is extremely complicated, and very frankly, I'll move on to that subject in just a short while. I would say that in this fact situation, if there's a full bench judgment and a 2-judge judgment which are contrary, the 2-judge judgment, if it does not refer to the full bench judgment, is what is called per incurium, and therefore it has no precedential value. But once again, appearing before the tribunals, we should be also aware of the fact that the tribunal does not have the power to say High Court judgment is per incurium. I'll come to that. I sort of jumped the gun, but per incurium basically means that a judgment does not have precedential value. But a tribunal, being a lower forum, can't possibly say Supreme Court judgment is per incurium, High Court judgment is per incurium. That would be gross judicial impropriety, and the tribunal member will seriously face the music if that comes to the knowledge of the High Court or the Supreme Court. So, but propriety would demand that we follow the previous judgment, the full bench judgment. And in the reasoning, the tribunal member would have to possibly write that I am following this because it is a larger bench, and as per the law of precedence, I am bound by it. That way, it would be safe. And as legal practitioners, you should ensure that the larger bench judgment also is followed. I'm very frankly, sometimes it may be against you, but I'm only giving you a theoretical point of view where there are conflicts between 2 judgments. These are the fact situations I could think of. There are situations where there may be conflicting judgments of other jurisdictional high courts. Which should you follow? So Karnataka High Court judgment, like I said, it's a no-brainer, binding on the Bangalore bench. What if there's a Bombay High Court judgment and a Calcutta High Court judgment which are contrary to each other? Then what is the tribunal supposed to do? Again, strictly speaking, law of precedence does not apply because neither judgment is binding per se, and therefore the tribunal would not be in error in not following either one of them. In which case, the tribunal has the discretion to follow what it feels is the correct proposition of law. So therefore, strictly speaking, if there are 2 non-jurisdictional high courts, it's an objective analysis that the tribunal would have to do and then decide which one to follow. Because strictly speaking, the tribunal is not bound by either of them. So if you see in fact, these notes, I'll circulate it because this is something that I wrote for myself. That is not a part of the notes circulated yesterday. But there is one judgment in the case of Commissioner of Income Tax versus Thane Electricity Supply Limited. This is in 206 ITR 727. Now that for me is generally the go-to judgment. If you want me to repeat, it's 206 ITR 727. That is my go-to judgment anytime I have any doubt regarding this highly complicated law of precedence. So I'll just read out some of the observations which hopefully are in line with what I have told you. First, the law declared by the Supreme Court is binding on all courts, except the Supreme Court itself, of course. That doesn't matter. The Supreme Court is not bound by its own judgment. But again, a 3-judge bench of the Supreme Court is binding on a 2-judge bench of the Supreme Court. So we will not bother too much about it. Decisions of the High Court are binding on the subordinate courts and authorities and tribunals under its superintendence. Therefore, the jurisdictional High Court's judgments are binding on all authorities within its superintendence. And for that purpose, you look at Article 227 of the Constitution, which defines the territorial jurisdiction of that particular High Court. Supreme Court then clarifies, jurisdictional High Court judgments are binding. However, it does not extend beyond its territorial jurisdiction. Therefore, a Karnataka High Court judgment will not bind the Income Tax Tribunal of Bombay, the Bombay bench. It will not bind the Delhi bench, and so on. Therefore, the ambit of the binding precedent is only within the territorial jurisdiction of that particular High Court. Then, the position in regard to the binding nature of decisions of a High Court in different benches may be summed up as follows. A single judge of a High Court is bound by a decision of another single judge or a division bench of the same High Court. Same would apply to a tribunal. A single member bench of the tribunal is bound by a decision of another single member bench of the tribunal or a division bench. Similarly, a full bench. It would be judicial impropriety. This is what the Supreme Court says. Judicial impropriety to ignore that decision. Judicial committee demands that a binding decision should not be over. So on. Then, a division bench of a High Court should follow the decision of another division bench. Similarly, tribunal, a 2-member bench of the tribunal is bound by a decision of another 2-member bench of the tribunal or a full bench. This judgment, which I gave you 206 ITR, was in the context of the High Court, but I will submit to you that it is equally applicable to the tribunal as well. So therefore, if one division bench differs from another division bench, it must refer the case to a larger bench. Therefore, the law of precedence requires a bench of co-equal strength to follow a previous judgment, and if it disagrees, it has to refer it to a larger bench. And lastly, where there are conflicting decisions of courts of coordinate jurisdiction, the later decision is to be preferred after full consideration. So therefore, that's what I was saying. If there is a later decision, the tribunal must follow that. But then again, with the usual caveat that if there's a larger bench, you follow the larger bench and so on. Now, last thing I'll touch upon before moving on to the next topic is the concept of, as I briefly mentioned, per incurium and sub silentio. I will not dwell too much upon it. I've already taken sufficient time. Briefly, just simply put, the concept of per incurium and sub silentio is an exception to the law of precedence. Per incurium simply means that a judgment has been passed in ignorance of a binding precedent or in ignorance of a particular provision of law. It could be due to inadvertence. Very often, tribunal members or High Court judges are reliant upon the advocates or the chartered accountants who are appearing before them to assist them in arriving at the correct position of law. If I don't give a particular judgment, I can't, and the judge has 30 matters, 50 matters in a day. It's unreasonable to expect him or her to go back to his chamber or her chamber, do their research, and then come out with their own judgment. They'll say, okay, Vikram has given this judgment, looks like it's correct. But quite often, an error is made over there. In such a case, that judgment can be said to be per incurium. Now, this is a slightly touchy topic because this per incurium concept cannot be invoked before a lower forum. So therefore, as I was saying, you cannot request the tribunal to hold that a judgment of the High Court or the Supreme Court is per incurium. And if they do that, it's gross judicial impropriety. They are bound by it, plain and simple. But when you're practicing before the tribunal, it will help you when you are trying to say that a judgment of another coordinate bench of the tribunal is per incurium. To that extent, certainly it will help you. So please keep this concept in mind. There are some judgments which I have referred to in my notes. These are some well-settled judgments in the case of Sandeep Kumar Bafna and Indore Development Authority, where they discuss this per incurium concept. But suffice to say that per incurium means the judgment has been passed in error. It could be due to inadvertence or whatever, where a particular provision of law has not been referred to at all, and therefore it is not binding under the law of precedence. Please keep that in mind. If let us say ABC company versus CIT goes to the High Court, ABC company versus CIT, without following a particular provision of law, the High Court holds in favor of ABC company. That judgment is binding on ABC company and the department, subject to, of course, appeal before the Supreme Court. But that judgment, ABC versus CIT, cannot be used as a precedent in a subsequent matter before the High Court, or it can be held to be per incurium in a subsequent judgment where the parties, let us say DEF company is there before the High Court. DEF can say, listen, or the department can say, please see the previous judgment. It totally ignores this binding judgment of the Supreme Court. It totally ignores this provision of law. Therefore, it is not binding on you. Please listen to me. In such a scenario, the division bench can say, okay, listen, that judgment is not binding on me. I will pass my own subsequent judgment, because that judgment is per incurium. So the per incurium concept is only limited for that limited proposition. Sub silentio is a branch of per incurium. Sub silentio basically means that if there is no argument made on a particular position of law, let us say there is some issue on which no argument was made at all, and as a consequence of which no decision is taken on that particular point of law. Therefore, we can say that judgment is silent on that aspect. But the conclusion may be beneficial to the department or the assessee, as the case may be. But on that particular point of law, you can certainly say that that judgment is sub silentio, and therefore it is not a binding precedent. Again, it is for the limited purpose of the law of precedence. It would be certainly, without any exception, binding on the parties to that particular case. So I think with that, I have sufficiently confused all of you over the last 1 hour over the law of precedence. So you can thank me later for it. But I hope, on a lighter note, but on a more serious note, I hope I have at least opened your eyes, or at least raised sufficient issues which got you thinking. Because sometimes we, as I said right in the beginning, we tend to overlook all these aspects, which is why I dedicated so much time to this. And this is so important, because finally, when we argue before the tribunal, very, very often, we are not reinventing the wheel. Most of the issues, particularly in income tax, most of the issues, except of course some new provisions and as far as TP and all is concerned, which is a new, a more recent and a nascent concept. Most of the earlier concepts, there are always judgments. There are judgments of the High Court, the judgments of the Supreme Court, the judgments of other tribunal benches, of the Bombay bench, of the Delhi bench. So very often we are not required to re-argue the entire proposition of law. Very often we rely on judgments. So therefore, I hope over the last 1 hour, I at least opened your eyes to some of these issues, which you will keep in mind when, as practitioners, you are appearing before the tribunal. All right, so then with that, we'll move on to some other concepts. Again, as practitioners, we very often use these concepts of natural justice and so on. I don't want to labor too much on it, because it's a very, it's too well settled to debate as much as we debated on the law of precedence. But suffice to say, natural justice, I'll just touch upon some concepts. Natural justice is something that is ingrained in the legal system in India. It is a part of what we call the basic structure of our constitution itself. And please remember, Article 14 envisages within its scope the concept of natural justice. And what is natural justice is, quite simply put, it is that branch of law that emanates from the concept of fairness. So when we are issued a show cause notice, or sorry, when an order is issued to us without a show cause notice, or when an order is issued to us without hearing us, we say that the principles of natural justice have been violated, or in Latin parlance, it is the principle of audi alteram partem that has been violated, and therefore the order that is under challenge is vitiated on the ground of violation of natural justice. I'll be honest, as practitioners before the tribunal, you may not come across too many cases of violation of natural justice simply because the natural recourse to any violation of natural justice would be to go to the High Court. But I thought I should stress upon that because as practitioners, you will also be advising assessees on what recourse should be had in cases of violation of natural justice. So let us say, as I was saying, without a show cause notice, an order is passed, or a show cause notice is issued without an opportunity of hearing, an order is passed, or show cause notice is on ABC, an order is passed on DEF. That again would be a violation of the principle of natural justice. In such a situation, generally, it is easier to go to the High Court, get that matter set aside, because the High Court, in exercise of Article 226 writ jurisdiction, would entertain such cases. I'll briefly deal with what this writ jurisdiction and all is in a bit. But tribunals, my experience tells me, not too many cases of violation of natural justice, simply because the tendency of the assessee is to go to the High Court directly and get that order set aside. But there may be some cases where the assessee chooses to go to the tribunal, agitate this issue. So therefore, we'll quickly deal with what this natural justice concept is. There are two concepts. One is that no man should be condemned without being heard, and that includes an assessee. So therefore, as I was saying, without a show cause notice, without an opportunity of hearing, even if the statute does not expressly provide so, the overarching rules of natural justice, which are ingrained in our constitution, require an opportunity of hearing, require an opportunity of showing cause against that particular consequence. Because all these orders, income tax assessment orders, first appellate authority orders, all of them have significant civil consequences. There are demands that are raised, there are various consequences to the order being passed. Now, when they have civil consequences, the rules of natural justice demand under the constitutional scheme that the person should be heard before such an order is passed. So therefore, that includes the right to be issued a notice, the right to present his case. There could be an opportunity of hearing. It could be an opportunity to present all the evidence. Now, let us say an assessee wants to present evidence, and the assessing authority, for whatever reason, says, I will not accept this document. Now, that is also a violation of the principles of natural justice, because in such a situation, it is held that there is not sufficient opportunity that is given to the assessee to present his case in the best manner possible. So that again is a violation of principle of natural justice. One is the right to adduce your own evidence. Second is the right to rebut the evidence that the department is relying upon. Let us say he relies upon a certain report, he relies upon a certain document, and he doesn't even present that document to you. He doesn't present that document to you with an opportunity to rebut that particular evidence. Even then, it would be a violation of the principles of natural justice. Therefore, that also would be possibly a fit case to go to the High Court. There are also judgments of the Supreme Court which say that even the right, let us say it happens very rarely, of course, but let us say there is a witness who is being relied upon to support the department's case. You should be given a right to cross-examine that particular witness. You should be given a right to cross-examine any document being relied upon by the department. So those are all concepts that are ingrained in the principles of natural justice. One interesting issue is whether there is a right to have legal representation. When I say legal representation, it includes the right to be represented by a practitioner. It could be a tax practitioner, chartered accountant, advocate under the Advocates Act, and so on. Again, broad principle in judicial proceedings, in any proceedings which are judicial or quasi-judicial in nature, the right to have legal representation is once again a part of the principles of natural justice. And if you're not given, and if the assessee is prevented from being represented by a chartered accountant or a lawyer, that would be a violation of his or her principles of natural justice. But if it is deemed that the proceeding is a purely administrative proceeding, in such a situation, there would be no right to be represented by a legal practitioner or a chartered accountant. Now, I'll give you an example. I can't recollect the name of the judgment offhand, but this is a case where the banks, of course, under that RBI circular of 2013, had designated a particular person as a willful defaulter. And now, as you all know, being named as a willful defaulter has significant consequences. He cannot take loans and so on. He's blacklisted forever until that willful defaulter tag is removed. But in such a situation, there is a committee of the bank headed by so-and-so senior officials of the bank who has to hear that particular person and then recommend to another authority whether he should be designated as a willful defaulter or not. Supreme Court, and this is a judgment by Justice Rohinton Nariman, where he wrote that this is a purely administrative function that is being carried out by the banks, even though it has significant civil consequences. But this is a purely administrative duty, and therefore he has no right of legal representation. But at the same time, he has to be heard. Nobody can be condemned without being heard. But I'm only on the concept, on the point of whether he or she has the right to legal representation. Right. So I was saying another concept is another offshoot of the principle of natural justice is to be given a copy of the report, any report that is being relied upon by the revenue. Otherwise, it would be a violation. Then another concept, of course, of natural justice is that no person should be a judge in his own cause, but that is frankly not applicable to tax proceedings at all, because it is, after all, a quasi-judicial proceeding where an income tax officer is frankly deciding your rights, and income tax officer is certainly interested in his own cause, but that is more for civil cases, so I won't bother too much about that. Another concept of another aspect of the principles of natural justice is the need for passing a speaking order. That is, that any order that is passed must contain reasons for the order being arrived at, failing which it would be a violation of the principle of natural justice. So therefore, if any order is passing, so X amount of tax is levied, and there is no reason for why that conclusion is arrived at, that would give cause for that particular assessee to approach a higher forum and get that order set aside, simply because it is a conclusion arrived at without reasoning, without application of mind, and therefore has to be set aside. I don't want to labor too much. As I said, natural justice is quite a very, very broad concept, and it is something which is ingrained in fairness. So, and it's far too well settled for me to labor too much upon it. Another question that you will possibly have to deal with as practitioners is, what is a substantial question of law? Because that is used in Section 260A of the Income Tax Act. So, as an assessee or as a revenue, you're permitted to file an appeal only on a substantial question of law to the High Court. That requirement is not there before the tribunal, but before the High Court, it's only on a substantial question of law. In fact, earlier law, before 260A was inserted under Section 256, it was a reference to be made to the High Court on only a question of law. But there is obviously some meaning attached to this phrase, substantial question of law. Again, I will not labor too much upon it. I've provided all the material, including the judgments of the Supreme Court and the Karnataka High Court, which basically say that substantial question of law concept is something that is borrowed from the CPC. Section 100 of the Civil Procedure Code requires appeals to be filed only on a substantial question of law. So this is a concept that is borrowed. So broadly speaking, the Supreme Court has said that what is a substantial question of law is frankly this, that the question of law must be of general public importance, and it must directly and substantially affect the rights of the parties. Now, this is a fairly watered down concept, to be very honest. It's not cast in stone, because there are even judgments of the High Court which say that, let us say the tribunal has dismissed an appeal on the ground of limitation, saying that the appeal was filed belatedly and there is no cause for condoning the delay. There are judgments which say that even that gives rise to a substantial question of law. So once the High Courts have said even limitational grounds give rise to substantial questions of law, then it is safe to assume that the concept is very, very broad, and substantial question of law would cover most questions. And what this concept I want to focus on a little bit, maybe for the next 5 minutes, is the concept of res judicata. Now, that is again a legal jargon which is often thrown around in the tribunal, saying that it is one issue cannot be raised because it is res judicata. Res judicata, simply put, is covered again. Once again, it is a concept under Section 11 of the Civil Procedure Code, but it can also be borrowed to a very, very limited extent. And maybe couch this with this caveat that in tax proceedings, the concept of res judicata has very limited scope, but it does have scope. So therefore, I thought I should explain what this concept of res judicata is. Res judicata simply means that if a particular issue has already been raised and it should be directly and substantially, that is the words used in Section 11 of the CPC, it is directly and substantially issued in a previous case, then that same issue cannot be permitted to be re-agitated. Now, the reason for the concept of res judicata is because the legislature and the public in general requires that there must be some finality to litigation, and that the same issues cannot be re-agitated over and over and over again. So therefore, if a particular issue, let us say from a civil law concept, the issue is whether the particular property was a subject matter of a partition deed, yes or no. Or was it a subject matter of a will? If it is not a part of the will, then possibly it is subject matter of partition. That issue has been raised between, let us say, party A and party B, and that question has already been answered and has attained finality in favor of party A. Party B cannot subsequently file a suit once again seeking partition, because that issue has already been decided in favor of party A, saying that the subject property cannot be a subject matter of partition. Let us assume so. It is said that issue cannot be raised once again, because then there is no finality to litigation. Then any aggrieved party will go on raising that issue. Once again, please consider. And let's say a new judge comes, or maybe a favorable judge who has taken a more lenient view in such cases. I want to try my luck again. That is opposed to public interest, and therefore the concept of res judicata has been evolved and has been adopted in legislation by way of the Civil Procedure Code. But there are judgments in the context of income tax which say that the strict principles of res judicata cannot be applied in the tax proceeding, because each assessment year is a separate unit, and therefore it cannot be said that, oh, this particular, let us say this particular deduction has already been given in this particular year, therefore the concept of res judicata, and it has already been held in favor of, say, the assessee, the department cannot raise this issue in a subsequent year. The department can raise that issue. You cannot say that the department is foreclosed from raising that argument because the concept of res judicata applies. It cannot be done so. It certainly, for the same assessment year, yes. Let us say the matter is finally decided by the High Court and subject to a further appeal, that matter cannot be re-agitated for the same assessment year. But for different assessment years, certainly it can be raised, and let us say there is some different point of distinction, it can be distinguished as well. But if you see the judgment of the Supreme Court in 1990, I don't want to read out this judgment because this is there as a part of the reading material I've given you. The Supreme Court has said, however, while dealing with the principle of consistency and the principle of res judicata, unless there is any material change justifying the revenue from taking a different view, it shall be improper for the revenue to take a contrary view. So therefore, Supreme Court has said, yes, different assessment years, different units, res judicata does not strictly speaking apply. But since the law has already been crystallized on that particular issue for another assessment year, even though it is open for the revenue to try and rake up the same issue again, it is most improper for the revenue to do so. So those judgments are there. There's one Municipal Corporation of City of Thane versus Vidyut Metallics, Radhaswamy Satsang versus CIT. Those judgments are the Bibles as far as the concept of res judicata is concerned. If you refer to the judgments, I think the issue will be sufficiently clarified. So therefore, I will not labor too much of it. But suffice to say, res judicata concept is a public law concept in the interest of finalizing litigation. Since assessment years are different units, strict principles of res judicata will not apply. But propriety demands that if an issue has been resolved for a previous assessment year, the same should be followed for the next year, and the department or the assessor for that matter should not raise that issue for another assessment year. Then as far as there are some other concepts which I think the reading material will sufficiently cover it. Again, as I said in the beginning, there are some concepts as a legal practitioner, I thought I'll bring my experience to the table, because very often I know that you are, as chartered accountants, assessees come to you and say, sir, can we go to the High Court? Can we file a writ petition? So I just thought very, very briefly, I'll just touch upon the concept of what is a writ petition, when these writ petitions can be entertained, because very often the assessee has two options. One is follow the general appellate route, in which case he has to go to CIT appeals. Let us say CIT appeals pass an order against him. Even then he has two options. He could go to the ITAT or he could go to the High Court. So as practitioners, you are required to suitably advise your clients who are the assessees as to what is the correct approach and what is the appropriate forum to file a petition before. I won't go too far into it. Writ petition is very, very limited in scope. My advice is, if there is a proper recourse, an alternate remedy as it is called, which is provided under the statute, which is the appellate route, I would advise you to advise your clients to follow that route, except in certain well-established exceptions. One is violation of principles of natural justice. Therefore, if there is no hearing given, if there is no show cause notice issued, or if a show cause notice is issued and it is predetermined the issue, or if, as I was saying, show cause notice is on ABC issues and order is on DEF issues, then it is a violation of principles of natural justice and writ petition is maintainable. Or if you are challenging the validity of that very provision itself, let us say there is a new provision which imposes a liability, and you want to challenge that provision itself, you cannot do it before the tribunal, because only the High Court and the Supreme Court has the power to strike down a legislation as unconstitutional, ultra vires, or a rule for that matter, or a notification or a circular. That is the second exception. And third exception is where the order itself can be shown to be without jurisdiction or in excess of jurisdiction, because all statutory authorities are bound by the four corners of the law, and whatever powers are conferred by that particular law is all that the statutory authority can do. He cannot do it cannot go 1 millimeter beyond the circumference of the jurisdiction conferred on him. And if he does do so, a writ petition is maintained. So therefore, my advice to you is, unless you can, from the assessment order or the first appellate authority's order, discern that there is a lack of jurisdiction, there is a violation of principle of natural justice, or there is a fit case for challenging the validity of the very provision or the circular or notification itself, the general appellate route is always the preferable route, because if you then approach the High Court in the absence of these three exceptions, the High Court will likely say that, sorry, you have an alternate remedy, please go file an appeal, follow the general appellate route. You can always come back to the High Court under 268. So therefore, as far as writ jurisdiction is concerned, I think I won't labor too much upon it. Suffice to say, it's an extraordinary jurisdiction of the High Court under Article 226. And unless, as I said, you can point out these three exceptions, the general appellate route is always the advisable route. Then there is one more concept of which I thought I'll touch upon, about retrospectivity. Very often, when arguing matters before the tribunal, you're faced with retrospective laws or laws that are sought to be applied retrospectively. Again, it's a very, very vast concept, but the general rule is this: there is a presumption of the prospectivity and not retrospectivity of all legal provisions, unless it is specifically stated so. Unless the provision says that such and such provision shall be deemed to have been inserted with effect from some anterior date, it is always presumed that the law will apply only from the date on which it has been enacted. Even if it is retrospectively inserted, that law, if it takes away any vested substantive right, it can always be the subject matter of a challenge, saying that that retrospective law is violative of Article 14, Article 19, Article 21, and so on. Therefore, you can challenge the retrospective law. And the third concept is that retrospectivity can be presumed or assumed from some of the wording of provision, but that is a very, very dangerous concept. And I would generally advise you not to tread that far, because there are judgments. There are judgments of the High Court, judgments of the Supreme Court, which say that if certain words are used, for example, there is one case of Zail Singh, which say that the word substituted, if the legislature uses the word substituted, it indicates that the legislature intended to give it retrospective effect from the date on which the original provision was enacted. But that is not the general rule. That is again to be discerned from the facts and circumstances of each case. And that cannot be, because very often legislatures, and I have seen that particularly the state legislatures, very, very, and I should say inadvertently and haphazardly use the word substituted. But I can tell you for a fact that they don't need to give it retrospective effect, so don't use it as a general concept. But the well-known exceptions of retrospectivity are: one is a validating act. Again, you will come across in the course of practice, you will find number of some enactments which are called validating acts. Validating acts generally are retrospective in nature. Validating acts are those enactments which are brought about in order to correct or validate certain errors that have been pointed out by a judicial authority. For example, the High Court may have said or may have commented on a particular provision of law, may have even struck down a particular provision of law, saying that that particular provision is not in accordance with the Constitution, or it gives a very different connotation and so on. But in such a situation, the legislature can come out with a validating act, setting right the errors that have been pointed out by the court and giving it retrospective effect. In such a situation, the act will have retrospective effect. That is from the date on which the original provision, which was interpreted or struck down by that High Court or by the particular court, it will come into effect from the original date, whereas it's called a validating act. The other act is another example of a retrospective act is one that has is clarificatory in nature. Let us say there is a provision which intends a particular meaning, but there is certain ambiguity in it which gives rise to some confusion. In such situation, the legislature may come out with an explanation, or it may come out with an amendment to the provision itself, which throws light on the ambiguity. In such a situation, the law will have retrospective effect, and those are called clarificatory amendments. So broadly speaking, when you are faced with retrospective laws, see whether the legislature truly intended it to be retrospective, see if it's a validating act, see if it's a clarificatory amendment, and so on. If it's not, then the presumption is that it has a prospective effect. And in worst case situations where there is a retrospective amendment and it, let us say it imposes a tax, that is a very, very egregious case, but it imposes a tax liability retrospectively, then what essentially the retrospective law is doing is that it is imposing a fresh liability which could not have been foreseen earlier, and therefore is affecting a substantive right that is vested in that particular assessee or in the assessees. Therefore, in such situations, that law can be challenged as being arbitrary and unconstitutional. Then there are some, I think I'll wrap up in 5 minutes. While arguing cases, you will come across a concept of preponderance of probability. So therefore, assessing authorities, or sometimes even the first order authorities, they will assume certain additions or deductions and so on, or as in the absence of concrete evidence. The Evidence Act also gives certain leeway. It allows even the civil courts to assume, based on the preponderance of human possibility, as to what a particular person could have done. Now, classic cases in the criminal law aspect, would a person, after having committed a crime, have run away? Would he have gone to a particular place? In such a case, the court is called upon to examine whether a reasonable person in a given situation, would he have reacted in that manner, and given the preponderance, basically you're balancing the human possibilities and saying, yes, it is possible that this person has done so. So therefore, if there is some undisclosed income and the explanation is that that income is from a particular source, but you cannot show, you're not able to show that it is from a particular source, then by way of a preponderance of human possibilities, the court can say that yes, it is possible that it is from a particular source. I mean, again, these are very, very, very fluid concepts, but I think hopefully my note will help you. But last thing I'll touch upon before concluding is when we're arguing stay applications. This is, I think, again, very, very important. We need to understand this concept of a prima facie case, and two, what is called the balance of convenience. Because the three important principles that the tribunal will consider, we ought to consider while deciding whether to pass a stay order or not is one, whether the assessee has been able to make out a strong prima facie case. And by strong prima facie case, it means that on the face of it, or on a preliminary examination of the case that has been made out before me, without going into the greater detail, the finer details, that if the assessee is able to make out a prima facie, a good case for a stay, then yes, the first box is ticked. Second is that the applicant will suffer, the person who is seeking stay will suffer irreparable damage. Let us say there is a demand for, say, let us say 100 crores, and it is only a 120 crore company. And 100 crore demand, if it is allowed to be continued, it will virtually wipe out the company itself. So therefore, there will be irreparable damage. That is, again, a very fluid concept. And third is the balance of convenience has to be in favor of the person seeking a stay. Now, what is this balance of convenience? Once again, it's like applying a weighing scale. It's like using a weighing scale and saying, by giving a stay and by not giving a stay, who am I causing greater inconvenience to? And if I am causing a greater inconvenience by not giving an interim order to the applicant, to the SSC, then the balance of inconvenience is in his favor, and therefore it necessitates, it requires me to give a stay order. So therefore, prima facie case has to be made out. Balance of convenience also has to be shown. Of course, irreparable damage, which is really an offshoot of the balance of convenience. Because balance of convenience, finally, it's like weighing the inconvenience caused to either party. More inconvenience to the department or more inconvenience to the assessee. If there's more inconvenience to the assessee by not giving a stay, then it's a fit case for giving a stay. So I think there are other concepts which which I honestly had predicted would not permit me to go through, but I chose not to go through them in detail because those are fairly easy concepts to wrap your head around as long as some of the judgments are referred to. I have noted that in the material I have circulated. I hope all of you have received it. So if you have any doubts on those concepts, you can always have reference to my material. Hopefully those issues will be resolved. So I think on that note, I think I will stop for now. I won't take any further time because we only have about 20 minutes left. And I already see a number of questions popping up, which I have not been able to open. So I think we can throw the floor open to questions and we can hopefully wrap up as soon as possible and enjoy the rest of the Friday.
Sir, there are about a bunch of, I would say, 10 questions. With the permission, can I read them out, sir, one by one?
Sure.
So the first question is, sir, will a full bench decision of other bench, say Delhi, binding on Bangalore division bench?
Here again, if there is a judgment of the Bangalore bench, even if it is a 2-judge bench, and let's say there's a full bench judgment of the Delhi High Court, the Bangalore bench must, as per the law of precedence, follow only the Bangalore bench judgment and not the Delhi judgment. That's what the law of precedence requires them to do. Otherwise, like I said, it would be impropriety to not follow. But the correct course of action there, frankly, would be for the subsequent bench to refer it also to a larger bench in Bangalore, so that the Bangalore bench, full bench also is constituted, and then they can consider whether the Delhi bench is correct or not. They are not bound by Delhi bench. So that would be the correct recourse in my opinion.
If subsequent division bench does not follow earlier division bench ratio, can a writ be filed since appeal will delay the outcome?
Yes, in my opinion, I think, see, I'll tell you one thing about writ jurisdiction is that it is an extremely, pardon me for using the word, but unruly horse. It's there's a famous story of, I think in sometime in the 1980s, the issue was the difference between, I think, a game of skill and a game of chance. And in the Supreme Court, if you're aware of the procedures, Mondays and Fridays are generally what they call miscellaneous days, where you're on a good day, you're given about 30 seconds to make out your case. So I think the Supreme Court commented saying that, listen, what you do on Mondays and Fridays is a game of chance, and what you do on Tuesdays to Thursdays is a game of skill. So writ jurisdiction is very much like that. It varies from judge to judge. It varies from day to day. I'll give you an example of what happened to me today. I was, of course, this is a 482 petition under the CRPC, appearing in a criminal petition, where before the same judge last week, not the same case, of course, totally different case, totally different facts. I was seeking stay of investigation of an FIR. So not last week, just before the vacations, must have been maybe second week of December or so. Same judge, first time the case came up, he heard the case, okay, stay. Today, as soon as I argued today's case, this is of course with the disclaimer that the facts were totally different. Today the judge says, "Illa Vikram kodakagala stay, notice issue." I said, well, "What happened?" "Illa, procedure requires me to issue notice before giving stay." I said, no, I couldn't tell him, but you yourself gave me a stint 2-3 weeks ago. Anyway, so what I'm saying is, it really depends even from day to day. So if a subsequent DB does not follow an earlier DB ratio, I would say you can take a chance with the ring, because then the High Court can be, if I was arguing the case in the High Court, I would say that, see, this is a bench within your judicial superintendence. This is what the bench is doing. So therefore, kindly exercise writ jurisdiction, particularly Article 227 jurisdiction, and set right that error. So I would advise that, but again, with the disclaimer that bad day, not bad judge, but a difficult judge, it's possible that he'll say, listen, file an appeal.
What if the cause of action arises in multiple states?
Very good question. Cause of action is a huge, if you see, and I'll answer this from a writ jurisdiction perspective. You kindly see, if you open the Constitution, there's Article 226, Clause 2, which says that even if a portion of the cause of action arises within the territorial jurisdiction of a particular High Court, then you can approach the jurisdictional High Court. Now, so therefore, if in the income tax perspective, it should not give rise to too many issues, because there's an assessing officer sitting in Bangalore, there's an assessment order passed in Bangalore, CIT appeal sits maybe in Bangalore, maybe Mysore, wherever. It doesn't matter. There's no issue over there. The issue, I'll tell you, there's like judgment. The name is not coming to mind immediately, but I'll probably send it across to you later. There's a very interesting judgment of the Supreme Court, where I still remember there is an assessee in Lucknow, assessing officer in Central Excise, assessing officer Lucknow. He files an appeal, appellate authority, first appellate authority, the CI, not the CIT, but the Commissioner of Appeal sits in where I think Lucknow again. At that time, the CESTAT Delhi had jurisdiction over all appeals arising out of matters arising out of Uttar Pradesh as well. So CESTAT Delhi passed an order. I think it was against the assessee. It doesn't matter whose favor it was. Then the matter was taken up by the losing party before the Delhi High Court. Delhi High Court said, sorry, I don't have jurisdiction over this. And merely by happenstance of the fact that the CESTAT sits in Delhi, Delhi High Court doesn't have jurisdiction. That was taken up in Supreme Court. And Supreme Court said, yes, Delhi High Court is absolutely correct. The original authority sat in Uttar Pradesh. The assessee was in Uttar Pradesh. Therefore, the place where the original cause arose is the High Court in which the jurisdiction will, the High Court which will have appropriate jurisdiction. So therefore, a cause of action arises in multiple states. In the civil dispute, yes, there are multiple issues which let's not go through over here. But generally in the tax context, this is the only real issue I can foresee arising. I can't for the life of me get the name of the judgment, but I'll come up with it. Hopefully it'll come to me now, or otherwise I'll send it to you guys later.
Now, as a continuation to this question, so let's say I'm an assessee residing in Bangalore and there is a search conducted in my business premises throughout the country. And then there is some irregularity or illegality with regards to search conducted in my business premises in, let's say, Delhi. Right. So if I have to file a writ, it will go to Delhi High Court or Karnataka High Court?
If there is a search conducted in Delhi and you're aggrieved by the search in Delhi, I would suggest Delhi High Court would have the jurisdiction. But if there are multiple searches conducted, say Bangalore, Delhi, everywhere, then frankly, you could file the writ petition in either one of the high courts and show under Article 226 that 226(2) that even a part of the cause of action arose over here. You can't do that because if it, like I said, if it's only a search in Delhi or aggrieved by, if you approach Karnataka High Court, they may say go to Delhi. But if you tell the Karnataka High Court, say there's a search on the same day in Delhi, say a search on the same day in Bangalore as well, Bangalore would have. I'll give you an example. In fact, this is not in an income tax case, but in a criminal case I appeared in November. This is an entirely Chhattisgarh-based entity, Chhattisgarh-based person. He happened to be in Bangalore for whatever business purpose. I have no idea. He was in Bangalore in a hotel. The income tax authorities Bangalore raided him in his hotel the criminal proceedings happened because he tried to flush down his iPhone and tried to swallow some evidence. It was quite uh, strange, but the criminal proceedings are trying to destroy evidence and so on. So I was asked to appear for him in a criminal petition. There had nothing to do with the income tax case at all. But the first question the court asked me was, Chhattisgarh ho gayi kal raid? I said, no, the raid happened over here. Karnataka High Court has jurisdiction. It was upheld. Karnataka High Court finally passed an order, of course, holding against me on the merits of the case, on a totally different aspect, but upholding jurisdiction. So you can file it where the raid happens.
If sufficient time is not given to respond to show cause notice, say only 5 days is given, does it violate the principle of natural justice?
If the statute demands a particular period, say 30 days has to be given, and they give less than 30 days, straight away, it's a statutory violation. It can be challenged. But if the statute is silent and say only 5 days is given, then yes, I would say it varies from fact situation to fact situation. Let us say it's a 100-page show cause notice and he gives you 5 days to reply. Then it's an open and shut case. I immediately go to the High Court and say, listen, you gave me 5 days time for a 100-page show cause notice. But if there's only one issue raised, one small issue saying that on whatever issue, and it's a very, very innocuous issue, 5 days the High Court can say, listen, you are given sufficient time. It's one small issue. What stopped you from giving some document? What stopped you from giving a reply in 5 days? So it is fact specific, but generally speaking, the statute, if it gives a particular period of time, it has to be followed.
So in all these cases where the principles of natural justice are violated, so ideally, what should be the outcome of the case? Should the proceedings be quashed altogether, or the officer should have a second inning?
Quashed and remanded. So if you're challenging a show cause notice, saying that it's a premeditated issue or it is without jurisdiction, the show cause notice will be quashed. Of course, the appropriate authority can issue a fresh show cause notice. Or if it is an assessment order, saying that you were not given sufficient opportunity of hearing before the order was passed, the order would have to be quashed, and the assessing officer can always issue a fresh show cause notice, give you an opportunity of hearing, and the proceedings will have to restart afresh. But subject to limitation, of course.
Can a person being subjected to search and seizure under IT or GST demand right to attorney during such search? Can his attorney or any other person approach High Court to direct authorities to allow searched person meet his attorney?
I don't think you have a right to an attorney during the search proceedings. That would be stretching it, I feel. But again, I'm not, I have to be honest. I don't think there is any judgment which mandatorily requires an attorney or a practitioner to be present at the time of a search. But if there is, certainly if there is an arrest or anything being made, then there's a totally different situation. But during a search, I don't think there's a right you can which you can demand. But that is subject to correction. I can always, if required, I'll check that. And I'll correct myself if necessary.
So your views on ex parte orders vis-a-vis principles of natural justice. Under what circumstances the shelters of principles of natural justice can be taken in higher
Ex parte orders by their very nature violate principles of natural justice. But if show cause notice is issued to you repeatedly, say, let us say it is given to you, you don't appear. Opportunity of hearing is given, you don't appear. Then the officer can legitimately pass an ex parte order saying that sufficient opportunity was given. He or she chose not to appear. I'm passing an order. In such a case, you can't then plead natural justice because then the court will say you were given sufficient opportunity. What stopped you from appearing? So again, it depends on your conduct as well. And one of the most important concepts of writ jurisdiction is when you approach the High Court under writ jurisdiction, you are presumed to have approached the court with clean hands. And if you have been in any way non-diligent in working out your rights, or like I said, like I was giving the example, you don't appear before the authority, you lose your right to demand a writ from the High Court or request a writ from the High Court.
Can you briefly differentiate between retrospective and retroactive?
Oh, that's a very good question. See, retrospective laws would generally, like I was saying, they apply, the law itself is retrospective in nature, but retroactive laws are laws that are prospective, but have sort of retroactive connotation. But frankly, this is a whole is an ocean of material out there, and what I'm telling you can easily be sort of contradicted by any other person. But this is what I understand. Retrospective, the law itself will apply. Let us say in 2020, a law is brought about and says it shall apply with effect from 1st April 2019. The law itself is retrospective, which means the law itself applies from 2019. But a retroactive law is one that applies from 1st April 2020 itself, but it would apply to it would have consequences even prior to its date of enactment. So that, broadly speaking, is the difference. But like I said, that is a whole new subject, and there's an ocean of material out there. I can, whoever asked this question, if they can email me, I'll send some judgments on it. There are some judgments. In fact, I thought of including it in the material, but I didn't want to further complicate it. But since the question is asked, I'll certainly add that. I can send it across.
If an if an if an ITAT in its pronouncement provides ratio dissent ID in regard to judicial pronouncement of Supreme Court and High Court as well, will the ITAT pronouncement be referred on priority?
Sorry, can you just come again? Sorry, I'll just read that. If in an ITAT, its pronouncement provides ratio decidendi in regard to a judicial pronouncement of SC and High Court as well, will the IT I didn't understand. Will it be referred on priority? I'm not sure what the context of the question is, but see, as I was saying, ratio decidendi is really something that is the law that is laid down in that particular judgment, which technically binds the next. So if the ITAT passes a judgment, it binds the subsequent bench of co-equal strength. But I'm not sure will the ITA or what the meaning of ITAT pronouncement be referred on priority. I'm not very sure what that means, but I hope I haven't confused anyone with this. But to be honest, I got confused with the last question. So I'm not sure what exactly that means.
Madam, any other question that you see? I think there was some refresh in my screen and I don't see any further questions on my screen. Anything that
I think Mr. Raghavendra has asked one question. It says, when amendments are made to tax laws, lawmakers use the word substitute and inserted. Generally, insertion will have prospective effect and substitution will be of retrospective in nature. When the amendments are clarificatory or giving effect to a judgment, only then it's retrospective, else the word substituted be construed as prospective. Is this the established interpretation? See, the general law on retrospectivity, like I said, it's always prospective. Validating laws are almost always retrospective, and the law itself will very clearly say it is inserted with effect from a particular date. Now, the gray area is when the law doesn't say from when it is inserted. If it doesn't say and it uses the word substituted, then the court will be called upon to see the facts and circumstances of that particular case, and then sort of second guess the intention of the legislature and see whether the legislature intended to give it prospective application or retrospective application. And if after that analysis it comes to the conclusion that it is retrospective, then it can apply. But then again, when it applies that provision retrospectively, it has to be very careful to ensure that no settled vested rights are affected. So let us say some input tax rate has already been accrued to a particular person, and there is a law that which is subject to interpretation, whether it's retrospective or not. The courts will always adopt an interpretation which will ensure that there is no vested right that is being removed. So if there's input tax rate that's already been accrued, and that interpretation, by interpreting substituted to mean retrospective, it denies an input tax rate retrospectively, such an interpretation will be avoided and must be avoided at all costs. So that is, broadly speaking, the law on it. So if the law very clearly says that retrospective, then it's quite obvious. But if that law, while saying it as retrospective, abridges any vested right, I would suggest that law must be challenged, because there are judgments. There are judgments where retrospective laws have been struck down. In fact, some of you may remember there was one, I think section 15(5)(e) of the VAT Act, where a purchase tax was directed to be paid in addition to composition tax, retrospectively from, I think, some previous year, 2005, 6 or 6, 7. And that amendment came subsequently. That the retrospective effect of that law was struck down, relying on various judgments of the Supreme Court. There's one, I think, one Tata Motors judgment and so on. So the law on retrospectivity is fairly clear. If it takes away a vested right, the most recent judgment would be that Vatika Township. If you check Vatika Township, that would be an exhaustive analysis of the law of retrospectivity.
Madam, if there is any other question, maybe we can take one last question and then proceed for towards a formal vote.
Yeah. If the third party summon is issued to tender oral evidence, if the assessee is of strong opinion that subject matter is a question which is not applicable, can he opt to reply in writing stating the facts? Or is it necessary that he has to honor the summons?
If you don't, it's again, there's a practical aspect to it. If somebody summons you and you don't appear, and tomorrow you are litigating the case in a higher forum, I rest assured the department will use your absence on that particular day to prejudice the mind of the court. But let us say, I'll give you an example. I was appearing for a party who was issued an LOC, this lookout circular. The investigation was being carried out by the Enforcement Directorate. This person did not appear before the ED on a couple of dates. What it has to do with the LOC, if you ask me, practically, frankly, zero. But practically, it made a world of a difference because the court was prejudiced by the fact that this person chose not to appear despite the summons being issued. Then the court will say, oh, we're trying to hide something. But if you can give a written reply by way of an affidavit or so on, it will not affect your rights per se, but practically it would prejudice you if you were to litigate it in a higher forum. So,
yeah, one last question. How per incurium will impact the same assessee's case in High Court? Can we go ahead and take advantage of later order?
No, see, that's what I'm saying. The same assessee's case, let's say a judgment is passed in the case of, like I said, ABC company. There is no question of the department saying tomorrow the judgment in ABC company has been held to be per incurium. Therefore, I have a right to demand whatever demand was set aside. Absolutely no question about the fact that that judgment, even if it is subsequently held to be per incurium, is binding on the parties inter se. The concept of per incurium. So I'll give an example. I'll conclude with it. I was appearing for the state government in a batch of mining cases where there was some, time won't permit me to go into the merits of the case, but there were maybe about 300, 400 judgments that were passed taking a particular position. Now, when I had appeared for the state government, sometime in 2019, I urged the High Court bench then, the then Honorable Chief Justice, to take the view that all those judgments are per incurium. He accepted my judgment. He accepted my argument and said that yes, all those judgments are per incurium and held exactly the opposite. But at the same time, now those 400 persons who got favorable orders from the High Court, whatever order was passed, the Department of Mines and Geology could not have said, no, I will not do what the High Court has asked me to do or directed me to do because it has been subsequently held to be per incurium. It is binding on those two parties. But subsequently it is held to be per incurium. Therefore, those orders cannot be shown in a subsequent judgment and say, please follow this judgment. It is covered. It stops covering any subsequent judgment. It covers the two parties' interests.
I think if there are any further questions, we'll try to take them offline. We've exceeded our time limits already.
Thank you. Before anything else, thank you all for being a wonderful audience. And I hope the session was useful to one and all. And wish you all a happy weekend and a happy New Year also. I should have wished you all at the beginning, but I forgot. So I thought I'd take this opportunity to wish you all a very happy New Year. And thank you again for being a very patient audience and coming up with some very, very interesting and useful questions.
Thank you very much for such informative session, sir. I'm sure we cannot get understanding of these basic concepts by reading the book. So definitely we are much benefited. And what I understand, see, some of us may be only in compliance may not get into litigation, but mere knowledge of law is not enough even to prevent litigation. Understanding the basic principles of law will help us in better compliance and avoiding litigations. So we express our deep gratitude on behalf of KSEA and also all the attendees for your time and explaining the relevance of basic legal principles and jargons and the criticality in applying these principles in practical situations. Thank you very much, sir.
Thank you all.